Everyone, and welcome to a little bit of a special edition video from the Legal Studies Guide. This video is going to focus on a little bit of statistics. So just wanting to run you through some key stats, I guess, that we can find through different sources in our criminal justice system that are really going to help you just illustrate, I guess, some of the factors that affect the ability of our criminal justice system. So we'll talk a little bit about time and delays. And we'll also look at case numbers, illustrating things like why we have a court hierarchy, and then some of the stats around sentencing that can really help you flesh out some answers around effectively whether certain sentence types meet their purposes. So just giving you a bit of extra ammunition, I suppose, to provide further depth into your responses, which we know is really, really vitally important to be able to get full marks on an exam. As always, a quote. Hopefully you all get this one and understand the joke here, but it's a famous unknown quote that 73.6% of all statistics are made up. I can confirm that none of the ones in this presentation are. They're all real. But yeah, always be wary if people use statistics to try and win an argument with you. So, as always, just the same sort of intro slide. Look, our key knowledge days, we're just focused on literally and skills. We're focusing on literally everything across 3.1. So it's just going to be a broad video that's going to touch on a number of points. And effectively, we're looking at what are some statistics that are out there that can help us better evaluate the criminal justice system, can help us better talk about whether it's effective or not. So we'll jump straight into it. And I really like just sort of this visualization here of effectively the work that's done from the Magistrates Court up the top all the way through to the Supreme Court and then the Court of Appeal, which is this one here. The point of this data is to really illustrate the benefit of the court hierarchy and why we utilize a court hierarchy, and particularly that idea of both appeals but also specialization. So just to show you starkly what the figures look like, if we look at this little number up here, 122,000 criminal matters were initiated in the Magistrates Court in 2021-22. So across a 12-month period, 122,000. Okay? That's how many criminal matters were initiated. So that's a huge number, 122,000. And I want to illustrate the difference between that number and this number here, 2,315. This is the number of criminal matters that were commenced in the county court. So this is really starkly showing you why we have a court hierarchy. 122,000 summary matters in comparison to 2,300 indictable offences. And if we add in the Supreme Court, you'll see initiations, 110. So ultimately, about 2,500 indictable offences dealt with through superior courts versus 122,000 dealt with in the Magistrates Court. And this really illustrates, again, that idea of specialisation. The idea that courts will develop expertise. 110 matters only in the Supreme Court, and we know that they're matters such as often murder, super extremely high level drug stuff, possession, importation, etc. And the Supreme Court and the justices who hear these matters develop expertise in dealing with those complex legal things, particularly in explaining, giving directions to the jury on how to, I guess, approach matters like that, understanding the ins and outs of evidence that can be used, all of that sort of thing. These judges develop expertise in dealing with that. And then on the opposite end, with these 122,000 matters that are initiated in the Magistrates Court, your magistrates develop expertise in dealing with those. The ins and outs of how they can basically roll through those generally, I won't say as quickly as possible, but obviously in a much quicker fashion than holding a trial like we do in the county court. So this also speaks to this idea of administrative convenience, which you'll learn about in civil as a reason for the court hierarchy, but also shows us then as well the benefit of having an appeal system. So of these 122,000 criminal matters, you can see here that total cases including appeals in the county court, 3,600. So of these 122,000 that the Magistrates Court deals with, only about 1,300 of those are then appealed. So literally like 1% of matters that start in the Magistrates Court end up being appealed up to the County Court. And then this is our Court of Appeal data. Court of Appeal data here's appeals from County Court and Supreme Court. So of our 20, more or less 2,500, only 190 of them, so a little bit more, about 10% or a little bit under, end up as appeals to the Court of Appeal. So again, just illustrating here why we have a court hierarchy, why we have, 50, I think it's about 51 Magistrates Court locations around Victoria to deal with this huge volume of cases and deal with it in a much quicker way with judges who are experts in dealing with those sort of criminal issues. That then allows the County Court the appropriate amount of time to deal with these more serious matters and the Supreme Court on top of that. So really, really good numbers to have a look at to help you understand that. Just as well, while we're on the Magistrates Court in terms of data, we know the Magistrates Court is the court that hears all committals. So every single criminal matter effectively is going to come through the Magistrates Court. Most of those are summary offences, 120 plus thousand of them, but also committals. So indictable offences that are going to the Magistrates Court first to determine if they should go to trial or not. And it's just, just looking at this number to again illustrate the number that the Magistrates Court is dealing with. In 2021-2022, across that 12 months, the Magistrates Court dealt with 3,000 committals. And we know the discharge rate with committals is about 1 to 2%. So of those 3,122, we can expect that about 3,060, 3,070 of those would have been sent to superior courts then for trial, or at least for potentially a plea of guilty as part of that process. On average, committal proceedings take 3 days to resolve. Some are a little bit longer, some are shorter. So that's 9,000 days of court time that goes into committals. And this really sort of illustrates that idea that if we're not discharging matters at the committal stage, what sort of benefit are they achieving, and are they actually limiting access by just taking away further court resources in terms of dealing with them? So an interesting one to consider in terms of access, and also one of our recommended reforms, which is altering our committal system in some way, abolishing the test for committals, or even some people calling for them to be removed entirely. Timeliness always comes up in terms of access and delays being a factor that limit our justice system's ability to meet the principles of justice. This is Magistrates Court data again. You'll note that basically through the Magistrates Court we get 40% of matters resolved within 6 months, and 85% of matters are resolved within or finalised within 18 months. So if we sort of look at 85% by 18 months and 40% by 6 months, you're probably imagining, it's hard to find these numbers, but we're probably assuming that the number would sit close in terms of resolve within a year. The number would sit around 70 to 80% of resolved within a year. And particularly you'll see here that prior to COVID, we were getting like 70% of matters resolved within 6 months. So the Magistrates Court's generally pretty good at getting things resolved quicker, and therefore enhancing access and not huge delays. But we can argue or really clearly show that there's data that says that the impact of COVID has limited access in the justice system, because the Magistrates Court has literally got worse at clearing criminal matters, particularly within 6 months. So you'll see that there are 25,000 cases currently that have been pending for more than 12 months, which is a pretty big number. Timeliness in then the County Court, stepping up a level. A little bit of detail here about how the court was unable to run jury trials for approximately 13 months, which caused a big backlog. The annual report then goes into a bunch of the initiatives they've introduced. We don't really need to worry about that too much, but we need to see this is a really cool number to know. And that's that as of about 9 months ago now, and we won't get another one of these reports for a while, the estimated time to trial, so if you are committed, so if you have a committal, and it's hard to find data on how long after you're charged until you get your committal. There was a period of time where that was around 9 months. Don't want to be quoted on that, it could go either way. But once you're committed to then stand trial in the higher courts, as it stands at the moment, time to trial is approximately 14 to 16 months. So if we add time to committal on top of that and say it is around 6 to 9 months, we're already effectively talking, on average, from incident, from being charged, and there's sometimes a gap obviously between the incident and being charged. We're talking an accused person waiting 2 years to get their day in court. So that's a really, really considerable number in terms of how long that's hanging over someone. So again, we can talk back here about how clearance rates in the magistrates' courts have dropped, indicating that there's greater delays, which limits access. And it's the same in the county court in a really long period of time, and how that links then maybe to fairness in terms of reliability of witnesses, lack of equality in terms of some people waiting longer than others. It's actually like a lot lower. The time to trial in regional areas is actually 6 to 12 months. In pretty much every regional area, but 14 to 16 in Melbourne. So that's an interesting one in terms of equality. It's quite rare that the country is getting a better deal than the city, but there's one there that illustrates that. Just a little bit of extra data on that as well, just so you're aware. If we cut out, so this is the work of the court, if we cut out the 37% of matters that they deal with, which are appeals from the magistrates' court, and just leave these two things in here. This is basically the percentage of cases that go to trial because a person has pled not guilty, and that's 38%, versus people who plead guilty once they're committed, and that's 24%. So of the total cases that are heard in the county court, we can break this down and say effectively 60% of people who are committed to stand trial in the county court, 60% of people who are committed to stand trial will go to trial, plead not guilty. 40% of people will plead guilty. So not pleading guilty at their committal, or not pleading guilty in between their charge sheet and the committal. After it is sent to the county court, about 40% of people will still end up pleading guilty before trial. So that might be because, a range of things. They see all the evidence at committal and decide ultimately there's no point having a trial. Plea negotiations could be part of this. They could ask for a sentence indication. Lots of reasons why, but yeah, around 40% of people after they're committed to stand trial will plead guilty, according to the numbers. In the Supreme Court, just to look at that again, that number goes up considerably. So of the 61 matters that they cleared last financial year, 38% of those were through a plea of guilty. So well over 50%, actually going closer to 60+%. So almost flipping it in terms of in the Supreme Court. So you're much more likely to have people plead guilty to something that goes to the Supreme Court than you are to the county court, which is an interesting stat. In terms of the Supreme Court, you'll see, and it's hard to find numbers on average wait time, but they're only clearing, in terms of finishing matters, they're only clearing 45% of matters in 12 months, but then they're clearing 85% of matters in 24 months. So again, we can probably surmise from that the average time to trial and then having your matter cleared in the Supreme Court is probably similar to the county court and around that 18-month mark. So again, time to committal after your charge sheet is filed could be, up to 9 months, and then you're awaiting potentially 18 months for your trial. Again, it's pushing out past 2 years, which is, considerable delay and some good numbers to think about if you're talking about access again. Super quick one, just because it's important to put all of that into context. This is from the Juries Victoria frequently asked questions online. Average length of a trial in Melbourne is 7 to 10 business days. So effectively 2 weeks or less. If it's out in the regions, it's about a week to a week and a bit. This is just important to consider in the terms of what we've just spoken about. effectively after a charge sheet is filed, you go through committals, and then you get to your trial if you're pleading not guilty. We're talking 2 years plus for something that's then taking on average 10 days. So that's just important to contextualise the idea of how important all of these pre-trial procedures that we learn about are. Committals in terms of the disclosure of all the evidence to the accused person, then the plea negotiations that can take part, the ability for an accused person to ask for a sentence indication. All of these are things we're trying to gear towards to try and resolve it without having to get to this trial stage. But then ultimately the trial is, only like a 10-day thing or less than 2 weeks at the end of this really exaggerated long criminal process. So that's something else just to contextualise all the things that we learn about and how they happen. Now, getting into sentencing a little bit, most of the rest of the statistics we'll cover will be sentencing. This is data from the corrections website. Lots and lots of words here that you can read. You can pause this and have a read, but I want to focus on this number here. So this is the advertised government number in terms of recidivism in Victoria. So recidivism being the rate of return to prison within 2 years. AKA, if you're released from prison, what is the likelihood that you will be back in prison within 2 years? And in Victoria currently, that rate is 37%. So you're probably going to get away with saying, because the old rate was 40, you're probably going to get away with saying 40%. What we're effectively saying there is for every 10 prisoners that are released in Victoria at the end of their sentence, 4 of those will be back in prison within 2 years. Now, oddly enough, that's actually one of the lowest rates in Australia. Significantly higher in other parts of Australia. The Northern Territory is up at about 60%. This is the perfect thing, the perfect number to include if you're discussing imprisonment and its ability to achieve, say, rehabilitation or its ability to achieve specific deterrence. You can quite clearly say, hey, it doesn't, because numbers show, statistics show that 40% of people are heading back to prison within 2 years. Clearly, prison hasn't deterred them from committing crimes, or prison hasn't altered their behaviour, rehabilitated them in any way that stops them from committing crimes. So that's a really, really good number to know, helps you talk about imprisonment. If we then compare that to community corrections orders, so within 2 years of discharge from a CCO, we'll clear that one off. Within 2 years of discharge from a CCO, the rate of return to corrective services, so either a CCO or imprisonment, is 10%. So way, way lower. So effectively what we're showing here is that if you get put on a CCO, everyone who comes off a CCO, every 10 people, say, compared to prison, who come off a CCO, only one of them is back engaged with corrective services within 2 years. So, look, clearly there's reasons behind this. The people who are going to prison are likely people who've potentially had convictions before. Generally, we know that the average prisoner has more than one conviction in their past, often has been to prison before, as we see from the recidivism rates. So there's an argument that basically people who are in prison are therefore more likely to commit crimes, and that's why that number is always going to be higher. But it is important to note that community corrections orders are clearly having a decent rehabilitative effect if only 1 in 10 people are ending up back engaged with corrections within 2 years. So that really helps you argue that rehabilitation is a strong feature of a CCO and potentially deterrence as well. It helps show the offender that the behaviour was wrong because of the conditions attached to it, and the rehabilitation aspect of it is clearly working. So again, helps you talk about that in terms of CCOs meeting their purposes. Factors relevant to sentencing. This is a really, really cool graphic or really cool study that a fellow teacher shared recently, done by the Sentencing Advisory Council, which has some really, really cool resources. But these blue ones here are the views of, so don't stress too much about the grey ones, which are the views of jurors from those cases, but the blue one is the views of judges. And basically, after criminal matters were resolved and someone was found guilty and then sentenced, The Sentencing Advisory Council asked the judges how much weight they gave to aggravating factors. And this dark blue here, this 92%, is that in 92% of cases where there was a breach of trust, judges gave that factor a lot of weight. AKA, they found that really important as an aggravating factor, and that really impacted the sentence that they ultimately gave. It impacted heavily on that person's culpability. So you'll see here that generally speaking, judges are really, really keen to use aggravating factors in sentencing, and really, really keen to have aggravating factors have a big impact on culpability. So breach of trust, how vulnerable the victim is, how substantial the injury to the victim was there pre-planning to the offence, and did the accused person have prior convictions and should have known the behaviour was wrong. All of these things, a judge more than half the time said, hey, I gave a lot of weight to these factors when I was determining the culpability of the accused person, of the offender. This is in contrast to their mitigating factors, so same study, and you'll see here that the dark blue is a lot lower. And this is effectively, again, how much weight judges gave to mitigating factors. And in no instance did judges have that above 50%. So effectively what we're saying here is that judges were far more likely to sentence harshly. Judges were far more likely to increase the culpability of an offender than they were to decrease the offender's culpability. So things like how old the offender was were the ones that judges used the most. But things like if the offender had been a previous victim of physical or sexual abuse, judges didn't really care about that as a mitigating factor. Only 6% said it impacted how they thought of the offender and their culpability a lot. Whether they'd suffered hardship, whether they came from a disadvantaged background. Basically, judges saying they didn't really consider these things that important as mitigating factors. Even things like good prospects of rehabilitation, only 1 in 3 judges found that to be an important mitigating factor that they gave a lot of weight to. So in comparison to these aggravating factors. So just a little bit of, if anything, just some really good examples of aggravating and mitigating factors, but also helps you understand how judges use them in determining culpability. Again, from the Sentencing Advisory Council, just pointing out the difference between how we deal with summary offences and indictable offences. In the Magistrates Court, over 50% of cases that were sentenced resulted in a fine. So fine, if you see a Magistrates Court matter, it's more than likely going to result in a fine if the person is convicted. The next highest is adjourned undertakings, which are a fancy way of effectively saying a good behaviour bond. So an adjourned undertaking is someone's effectively released and said, if you come back before the court, say in the next 5 years, we will more or less put a conviction in for what you did. Otherwise, free to go. So that's 13%, and then imprisonment's 12%. So you can see imprisonment's really, really rare for a summary offence or even an indictable offence heard summarily. It's sort of like 1 in 10 will result in imprisonment, whereas fine's way up there. So that just sort of helps you, I guess, conceptualise a little bit how summary offences are dealt with in comparison to then sentencing in the county and Supreme Courts. So thinking back to the start, 122,000 matters in the Magistrates Court versus, the 2,500 in the county and Supreme. And in 74% of matters that went to sentencing in the county and Supreme Court, imprisonment. So see the stark difference there. As soon as something's an indictable offence that's dealt with through the county and Supreme, imprisonment is, 3 out of 4 times the sentence that someone is going to get. Community corrections orders next at 11.8, and then fines lower than that. So just in contrast to, and this is because we used to have a thing called suspended sentences that have been phased out, but it's just interesting seeing that in contrast to 2004, so 17 years ago, the rate of imprisonment was about 40%, and now it's up to 74%. So it's almost doubled in terms of how often we send someone to prison. which is an interesting statistic. Finally, the last few things I'm going to show you are some specific crimes and the sentencing that happens with them. So murder, 120 murder cases have gone to sentencing in the last 5 years, and in 100% of those, someone went to prison. So I'm sure that's not a surprise, but no other sanction has been used for someone convicted of murder. And I think the lowest term of imprisonment was, I think someone maybe got like in the 11 to 12 year range, but over 50% or close to 50% of sentence lengths were 25 years to life. So yeah, murder always results in imprisonment. This is in comparison to theft from a shop. I've just chosen that as the subsection of theft from a shop. Now, theft from a shop is technically an indictable offence, but because theft from a shop usually falls below, and I think the threshold number is $100,000, it is able to be heard summarily, which means even though it's an indictable offence, it's dealt with through the magistrate's court. And you actually see here that in the last 5 years, there's been 13,000 theft from a shops that have been dealt with by the magistrate's court, in contrast to 15 that have been dealt with by the county or Supreme Court. So it would have all been the county court. So even though theft from a shop is an indictable offence, literally always more or less being heard down in the magistrate's court. And theft, it's interesting, just, murder, you're always going to jail. Theft, you'll see that basically, imprisonment is still the most likely sanction, but things like community corrections orders and fines are really often used, or on what we would assume would be very low level theft from a shop, perhaps often involving young people even as well, or younger offenders. They're likely to get an adjourned undertaking. So again, that fancy word of saying basically a good behaviour bond. So you can sort of see that theft sentence vastly different to murder, as you would expect. If of these 15 matters that were dealt with in the more superior courts, 10 of them resulted in imprisonment. And we would assume that is because the theft was of a much higher level, which meant that it couldn't be dealt with through the magistrate's court, or the parties didn't agree to that, or the accused didn't want that for some reason. And as a result, more serious sanctions given. So interesting, just contrasting or understanding a little bit about why certain indictable offences are heard summarily and how often that occurs, and then what impact that sort of has in terms of the sanctions that you get. They are some key statistics that, as I said, might help you evaluate the criminal justice system. The really, really important ones that I think would be helpful are definitely understanding that idea of how long the process is, how much time it takes, and being able to then litter that into answers about things like fairness, equality, and access. What do the delays do in terms of the stress it causes? Is that fair on someone? What happens in terms of reliability of evidence over that period of time? Is everyone getting, the same level of delays? Are some cases being resolved quicker than others, depending on where you live potentially as well? So lots of little vignettes that you can get out of there that you can just sort of litter into an answer, like I said, and build in the depth that is required, because we know that it is more than just saying, hey, there's delays in the criminal justice system, so therefore there's no access. You've got to explain why there's delays and give some context around what those delays are. So there's delays because of COVID, and we couldn't have jury trials, and as a result, only 40% of matters in the magistrate's court are getting resolved, That's going to be a significantly stronger answer than just saying, hey, there's delays, which means there's no access. So that's the purpose of these statistics. Hopefully some of these things in here you find helpful. As always, drop us a line if you've got any questions, any feedback below. But all the best for any upcoming assessments that you have.